Okay, what time do we have? We are at the top of the hour. So, welcome everybody. For those of you who have joined us, we sure appreciate it. If you'd like to have a video screen on, it's up to you. And if you would like to ask questions during the presentation, uh, you may do it via the chat room, or you may just unmute yourself and ask a question directly. We'd love to hear questions, and we're happy to answer them as we go during the presentation. Um, so this presentation on behalf of the Fiduciary Education Forum. I am Todd Wohl with Braun International and Premier Estates International Real Estate. We are the hosting kind of founding organization that put the Fiduciary Education Forum event together about 3.5, 4 years ago. We do have a very specific website with past videos and information and presentations and so on. It's at fiduciaryforum.com. That's fiduciaryforum.com. So, with that, we've got a lot of good things to talk about today, and I'm happy to have Yulissa Zulaica from JKZ LLP, and Yulissa is the managing partner, and we've had the opportunity to work with her and some of her partners and associates at her firm throughout the state of California over the past, I don't know, 15, 18 years.
You're
And
dating us, Todd. You're dating us a
yeah,
little.
I know. Well, I have gray hair. So, um, I will, I'll just a quick introduction on us for those of you who don't know us at all. Premier, as I said, I'm one of the partners of Premier Estates and Braun International. We appraise, value, broker and auction real estate and business assets throughout California and in the US. We're probably the number 2 or 3 largest trust real estate company in the country. Our clients are fiduciaries, law firms, trust companies, family offices, private equity firms, et cetera, et cetera. And our websites we'll talk about that at the end. And so, Yulissa, why don't you start out and introduce yourself and your firm, please?
Sure. All right. Well, thank you, Todd, Connor, and the group for hosting today. Excited to be here. I see some familiar names, so nice to have everyone here. My name's Yulissa Zulaica. I'm a trust and estates attorney running the gamut from foundational to not so foundational planning, mainly taxable, administrations, and litigation. And generally, there's some tax complexity and or, international component to most of my personal practice, but our firm specifically, started as a boutique firm, kind of covering all of that, family law business. We have, I think, 10 or 11 attorneys, if that's all they do on the estate planning side, about 5 in litigation, family law, another handful. So full service kind of on the private client side, representing fiduciaries, professional fiduciaries, non-professional fiduciaries, beneficiaries, and so on. So today we're going to talk about foreign assets, taxes, beneficiaries, and a little overview of what I'm going to talk about, and happy to take questions. And if it's something I'm going to cover later or we're running out of time, I'll let you know. We can hold off, or I can be available at any time to chit chat. But I'm going to give you the takeaways at the beginning, I guess, even before I give you the overview. Is the point of this is I'm going to give you a lot of rules that I think it's fun. Not everybody loves taxes and forms and all these things, but it's a good tool for you as fiduciaries to note that there's issues there and there's other things that one needs to think about when administering a trust, an estate, or your power of attorney for someone that may have a vacation home in Cancun. There's different rules and requirements that you may be obligated to follow, and a lot of them carry personal responsibility. So I think that's the gist really of all this. There's a lot of rules. There's differences in how you do things when you have non-US people, grantors, beneficiaries, assets abroad, etc. And just you should just make sure you're working with a team that understands that there's some nuances. Okay. And that's what we're going to talk about today. What do you, as a professional fiduciary, need to be aware of when you're administering a trust in the US? What if we have non-US beneficiaries? And what if my US person during lifetime that I'm representing under a power of attorney, if they own assets and a bank account under a corporation abroad, have to do? And what do I do when they pass away? Okay. More specifically, we will get into some detail. I think one of the things to be careful, I'm going to give you the detail. Todd makes these slides available to you online, I believe, and it's important to know that there's a lot of nuance in this world that we're in, right, in the international context. And I think you probably already know this, just, probate, tax law generally, there's a lot of nuance. And I say that because people use a lot of the terms loosely and they assume, okay, I have a person that lives here, and they have a green card, so they're treated just like a US citizen. And that's not true. The rules are different for different purposes, income versus estate versus gift. So I just want to remind everyone of some of those nuances, again, really so you're aware of them more than anything. To make sure that at least to ask the question of your accountant, of your attorney, have we considered this? Is this a difference? Okay. Um, so when we talk about an international estate, how do we see that? What is it? And it can come up in lots of different circumstances. And again, it's not always in large estates. So some of the difficulties with administering estates, it's not that have an international component, is the fact that it's international. I don't care if it's $1 million estate or a 10, $20 million estate. It's going to be a step up in terms of things you have to think about. So it happens a lot when your US people move abroad, right? So that can create some reporting issues on the US side and also where they're living. Do they dismantle their trust? Do they keep it? And often you have to get rid of the trust because it can be problematic. US persons that are just buying assets abroad, how do they buy them? And, how do they sell them? So we're going to look a little bit on that. And then non-resident. So we have a office in San Diego as well as in the Bay Area. We're kind of a couple offices in California, and we have a lot of non-residents, people that are not U.S. persons buying homes in San Diego, Coronado, LA, right? So how should you own those things, and what are the different rules that apply to those people? All right. So dual citizens, U.S. persons, and that's kind of what we're going to see today. And I hinted at this before. Why does status matter, right? So again, people use terms very loosely here. Oh, they have a green card. They're like US citizens. For income tax purposes, that is true, but not for estate and gift. So the rules, depending on if you're a non-resident, a US citizen, a green card holder for more than 8 years, all the rules are different in each one of those cases. So that's kind of the gist of that, okay? And where you have assets can be treated differently. Some countries don't respect or look at trust. That won't work as an estate planning mechanism. So if you're the fiduciary administrator an estate, I'm currently representing one right now, and they've been having a hard time selling a property in Mexico because the proper planning wasn't done, right? So this does come up more than one would think. Okay. All right, rules. When we talk about an NRA, it's a non-resident alien. And I use that acronym because that's, when you do readings or you do a ChatGPT search or Google or even the codes, like that's what's commonly used. And that's a person who's not a resident or citizen of the US. Okay. You can become a U.S. Person for income tax purposes in a couple different ways. You're a U.S. citizen, so automatically you're subject to income tax here. Okay. And for fiduciaries that are serving as powers of attorney for individuals who are U.S. citizens or may not be, this is still very relevant. I think, if you don't work in this world consistently, typically U.S. citizen doesn't matter. Again, it matters if they own property abroad, even if it's an investment or vacation home, etc. But a U.S. person for income tax purposes is a U.S. citizen, a green card holder, and somebody who satisfied the substantial presence test. And I'm sure at some point you've heard, if you're here 6 months out of the year, 183 days, you're subject to income tax. Well, guess what? And again, what I'm talking about is at the federal level. I'm not looking at California specifically. There's rules related to this as well. But you're subject to income tax in California, but in I'm sorry, at the federal level. But I have a little exercise on the right. If you see the nuance, again, here's where the nuance, can take effect. It's not 183 years per year. You have to do an average of the last 3 years. So if I've on average been here 122 days, I meet the substantial presence test, right? And I may be thinking that I haven't met that yet. Just again, something to be aware of. Now, for transfer tax purposes, estate, gift, and GST purposes, a U.S. citizen is automatically, again, you're a U.S. person for transfer tax purposes. For estate tax purposes, it's someone who is domiciled here. Just because I have a green card does not mean I am a U.S. citizen or I'm domiciled here. Now, that is a very big factor in determining if you're domiciled here, but is not determinative. The rules actually say there's no black and white rule. Oh,
I'll take care of it. Go ahead. Go
okay.
ahead, Yulissa.
Sure. Yeah, and if there's a question or if I'm going too fast, I tend to speak fast. I've been working on it for 18 years, so I'm still working on it. Just let me know. But for domicile, there's no black and white rule, right? It's, what's your intent and facts and circumstances. And why do you as fiduciaries care about this? Because how you report and what you report on the tax compliance side is super important. Okay. If we have, often what I do on the planning side where clients where it can be a little murky is we'll do an affidavit and it might be a page or two long of all the reasons why I'm domiciled here in the US, right? And there's a bunch of case law, believe it or not, on this issue, on whether or not someone was domiciled here. And they look at all these factors. So I included some of the factors that are seen, some of it's in the regulations directly, but it's also in different cases. So again, important for you to know that a U.S. person can be a U.S. person for income tax purposes, but not for transfer tax purposes. Okay. And then, yeah, I think I mentioned this, so I'll keep going. But there are a bunch of exceptions also if you're here on a temporary visa. And then once you have a green card for more than 8 years, you're considered a long-term resident, and that's where other rules kick in. I don't know if you've heard the word expatriation, but if you ever leave the U.S., you could be subject to taxes on exit too. All right, this is a handy little chart. I like, put it on your wall if you want, if you think this is relevant to some of your practice. But when we talk about what are some of the difference on the transfer tax side, like it's a pretty stark difference here, right? Estate tax exemption, $60,000 versus almost 14 this year. That's a huge difference. So I'm just working now with a client who came to see me, and both parents, one parent passed away who was a non-resident, and unbeknownst to them, they own, more than a handful of properties in the States in a regular revocable trust and never filed taxes correctly. And now I have a huge estate tax liability, right? So again, if you're the fiduciary, you would be the one administering and making sure that the formalities are met, specific to filing an estate tax return if it's required. And here, $60,000, it's a pretty low threshold, right? It's not 14. There's no gift tax exemption on U.S. assets. So there's a gift tax of 40% if it's U.S. citized assets, and the U.S. citizen can give away 14 million. There's no annual exclusion to spouses. That's another big one I see messed up quite a bit. You do not have the unlimited marital deduction from a U.S. citizen spouse to a non-U.S. citizen. So important to know. There's ways around it through certain types of trust called a Q dot. But if you don't have that, it would eat away at that U.S. citizen's $14 million exemption. Okay. Any questions so far? Okay. So nuance and big picture. So I just gave you an example. I have a client whose parents passed away with a lot of real estate here in California, and they're non-residents, and they purchased it through a revocable trust. So for all intents and purposes, it's in their name. Now that it's in their name, now that it's in their name, I have exposure to estate tax. Okay. And so with that, I included a list of what's included in an NRA's estate, which is real property. There's interest in companies, U.S. corporations. So what's situated here? What do we have here? There's a few exceptions. One is a U.S. bank account if it's in cash. I like to point that one out. There's and the life insurance too, but because this pops up a lot. So if I have a bank account, regular checking cash account in the bank, and it has $1 million, that is not subject to estate tax when an NRA passes away. But if I have that same cash account held via brokerage account, right? Because a lot of the brokerage accounts have a cash fund within, and then they have their investments on the side. It is subject to estate tax. So you do have to be very careful on what types of accounts and where they are. That should be happening a lot on the planning side, but it doesn't. So as fiduciaries, if you're managing these estates, it's important to know, again, to work with people that are aware of these things. Okay. Gift taxation of an NRA. Again, the reason why I think it's relevant to you is you're doing the cleanup, right? So you're a trustee, you take over a trust administration, you're filing an estate tax return, and oh, how did mom and dad give the property to daughter? Oh, well, if they're non-residents, do I report it any differently? Did I have a tax that was due? I mean, it is your responsibility as a fiduciary to make sure that the compliance is done properly, right? So again, this is, it's my job, it's your accountant's job to make sure that we understand and know the nuances, but I think it's super important, and that's where you can add a lot of value to some of the cases and expand your clientele potentially if you have a foundational understanding of what some of these issues are. Okay. So I mentioned this briefly, QDOT, and it's a little out of context in the flow, frankly, but I think it's important because we often need local U.S. trustees for these trusts, right? So I mentioned earlier that from a non-U.S. citizen to a non-resident alien spouse to an NRA spouse, you have to have a U.S. trustee if it's over than a certain amount in order to avoid the estate tax altogether. So it's a backdoor way of getting the marital deduction when I don't have it available for non-NRA spouses. Okay. So U.S. trustees, we often work with trustees here to ensure that we have jurisdiction in California and we can avoid or mitigate the estate tax when the U.S. citizen spouse dies. Okay. And really, it's kind of like a marital trust. All income is required to be paid out, but there's an annual filing when there's distributions from that trust that do trigger an estate tax to be paid at the time that you would be responsible for. Okay. Foreign trusts. So I mentioned foreign trusts because a big thing I see happen, and I was just asked this question by a friend and my former partner was, okay, what if they're moving abroad, right? And this happens all the time. The US people move to another jurisdiction. And then I'd venture to say that most attorneys say, okay, fine, so long as it's not a problem in the other jurisdiction, then we're good on the US side. And I would disagree with that. I think it's an extremely nuanced issue. And what I mean by that is, from the US perspective, in order for the trust not to be a foreign trust, you have to have control by a US person, which we do. If a US citizen is trustee and controls the trust, no problem. If the court also has to have primary jurisdiction. So for all us Californians that are here, I don't know if there's anybody out of state, but if I'm in California, for a court to have jurisdiction, principal place of administrations, that's the appropriate venue, et cetera. Otherwise, what's my venue, right? And if I don't have control, if the US court doesn't have control, then another country can get jurisdiction. And then I fail my court test, which means what? Which means that now I have a foreign trust with annual reporting with requirements that if you don't do, you have a substantial penalty. for that. So this is something that I feel that people don't
Oh, this right away here, Sam.
look at enough carefully, but it's something to be aware of when people move abroad. And this is also where I often use professional fiduciaries in that context because I want to maintain jurisdiction here. It's not a problem for my clients still to have a revocable trust if they move abroad, but that's where I may loop, you all in to make sure that we maintain jurisdiction and I don't have any foreign trust issues, or we can, do away with that idea. So something that comes up quite a bit, actually. Everything I just said can be changed. There's treaties. So again, just know that in the back of your mind. And, countries that I work with more specifically, I know better than others, but there's a lot of treaties that can affect, some of the rules that I just mentioned. So again, just something to be aware of. Okay. Now, again, how is this relevant to me? So I'm trying to tie it as to, how is this relevant to you in your day to day? I think the biggest thing is as a fiduciary, you're going to have to ensure that your principal, if you're doing it under a power of attorney, or your trust and trustee or decedent even, that they did it right. Because of compliance, if you have a compliance issue, that will trail even post death and even onto the beneficiaries, and there can be some personal liability there for you as well. So I think that's how it's really relevant. I cite there just a handful of forms that are very common. There's more depending on what type of investments, et cetera, you individuals may have abroad. But reporting gifts from non-residents, you have to report them. And I have there $100,000, but if I get $50,000 from my friend John in France and $60,000 from my cousin Maria in Spain, I'm at 110, so total. So I have to report all of it, right? So people often mess that up too. If I have a foreign trust, accidental or not, then I have this other filing requirement. So that's why I list the forms there specifically, because those are pretty typical and are pretty typically missed. And then when people talk about FBARs, now there's another name, but I left FBARs because people still refer to them as that. It's if you have a combined balance at any point in time of $10,000 bank accounts and foreign accounts, okay? Combined value on any point in time. And then on top of that, there's another form, 8938, if the combined value, if depending on whether or not you're married, is 75 or 150,000. So again, it's nuanced. Just good for you to know that even having bank accounts abroad can be an issue. And I see this come up a lot. I had a client that called and said, I bought a vacation home in Costa Rica and a year ago. Okay, great. So what do we do with it? Oh, and by the way, I was advised by Costa Rican counsel to buy it in the name of a corporation and open a bank account in the name of the corporation. So now I have five issues, right? I didn't, I set up a foreign corporation. I haven't been filing tax returns saying that I have a foreign corporation. I have bank accounts, not filing the 35, I'm sorry, the FBARs or the 8938s because the advice I received in Costa Rica without consulting with US persons was, this is what people that are not from here have to do. So again, just important for you to be aware in case you're responsible for any of this. And then I just have some forms, and if the website's online, Todd, you can click on the forms. To this day, even though, again, my job is to know the nuances, I go and I look at the regs and we look at the case law. The forms themselves and the instructions on the forms are super helpful. It's a great cheat sheet. If I don't remember something off at the top of my head, I often go to the instruction form to look at that in terms of what am I supposed to report? What are the questions that are being asked, and what am I going to have to know for these forms? So I included a handful of them for you. Now, I'm sorry, not US, for foreign beneficiaries. So another thing I think gets missed a lot, and I think different accountants will approach this differently, is when you have foreign beneficiaries, technically speaking, you're supposed to do a withholding on the income. Now, the treaties can change what that withholding amount is, and often they need to get a tax ID for that. Now, will beneficiaries actually want to do that or do that and get a tax ID? Often not, right? So what do you do? So we've handled it a few different ways, but one way of doing it is also just have the trust pay the income tax. I had this really awkward situation. I'll just admit it. I don't know if it was the right way or not, but we had some income, trust paid the tax, and there was a small amount that my client as trustee was responsible for withholding. And we couldn't find the beneficiary, right? We couldn't find them. We couldn't do anything. So we submitted the withholding to the IRS, which is what this form is. You know, my client as trustee was the agent having to do with the withholding. And then we gave it to the IRS, but we didn't attach a tax ID. Not probably the right way to do it, but no other avenue was found. And my trustee was technically compliant, right? IRS has the money, trustee did their job, call it a day. So again, you as fiduciaries are responsible for these withholdings, and here's where some personal liability can occur. Okay. All right. So how does this impact you? Same thing. And this is how I've worked with Todd, who's sponsoring the event today. Is they've been great at the international level. They not just do domestic, but internationally to buy and sell property and also interest in businesses. So I have one foreigner and 8 other people that are here, and the foreigner just wants to be bought out. Maybe the third party, like Todd's firm, can buy them out. So they've been helpful in that way. But if your beneficiaries are in Mexico and you're selling the house here and there's gain, well, we want to make sure we do the withholdings, right? Again, you just need to be aware of that. So perfect example where that should be a trigger. I know I have to think that there's other rules that are going to be at play here. Okay. And in my example that I gave earlier, if I have a majority of the trust beneficiaries in the US and some in other countries, now I mentioned earlier that, okay, have the trust pay the tax, right? Well, if I'm a US beneficiary and the trust pays at a higher rate, well, now I'm mad that you trustee chose to do that because it cost me $20,000 more in taxes. I'm making those numbers up, but it can result in disparate treatment potentially for the beneficiaries. And how do you balance that with your duty to be impartial, right? So again, these are nuanced issues that you just have to work through and make sure that you're covered as best as possible that you're compliant with the rules and the laws here, administering the trust, and also full disclosure with the beneficiary. So just something to be aware of and when it can come up. And then the other example that I've had come up also, and Todd's firm has helped me with, is we had this one we were administering in state in Mexico, and there was a hefty estate tax here, and there was a huge home in Mexico that, Todd's company helped us sell. And that was one example. And then another example is, what if you are representing somebody under a power of attorney and the majority of their assets are abroad, Mexico or any other place for that matter? Right? You have an obligation to sell it to make sure they're taken care of here. So just something to be aware of. Again, when we think international planning, I think people still assume that that's a different world, but it's more common that we think in our day-to-day nowadays. So appraisals. I like to throw in a plug for appraisals. So I do a lot of the litigation on the trust side, which is probably my favorite, interestingly enough, but it's the same issues that we have on the planning side if we do not get good appraisals, okay? For a lot of the transactions, for estate tax purposes, for gifting purposes, and that's how we've also worked with Braun and Todd's company and to make sure that we have a qualified appraisal for what we're doing. And it depends on the context, right? If I'm just doing a simple probate for assets here, the probate referee usually appraises the property. Is that enough technically to set your new income tax basis? Technically not. Do people go beyond that? Mostly they don't. Do I see issues with the IRS or on audit specific to real estate? Not often, frankly. But I can tell you that that's not the appropriate way to set the foundation for income tax purposes. If there were an audit later, you really don't have anything to defend it other than the probate referee. And then in a trust administration, and some of the complicated and irrevocable trusts do allow for trustees to determine the price based on X, Y, and Z. So that's why I have that here. But frankly, the point is that for gifting, for reporting, for income tax purposes, for selling purposes, you need a qualified appraisal. And it's a little bit more cumbersome than one would think. It's not an opinion by a broker. It is a full-blown, what's the purpose of the appraisal? What are we doing it for? What's the date? And what are the qualifications? And the tax regulations actually go through a list of what's required for it to be a qualified appraisal. Why do I care? If I don't have a qualified appraisal in certain instances, specifically with my gifts and my estate taxes, then the statute of limitations doesn't trigger, right? The IRS can come back and say, well, that gift tax return that was filed 15 years ago when you are now administering the estate, that doesn't matter. It wasn't done properly. There was no qualified appraisal. So I'm opening that up again. I'm evaluating that with the estate tax return audit, and then we open up a can of worms, right? And imagine going back 15 years to do that qualified appraisal. So, Todd, I don't know if you want to say a little bit about, what your experience has been and kind of how we've, worked with you in that regard and why it's important too.
Well, look, everybody, qualified appraisals are based upon the credential for what it needs to be valued. Most of you are valuing real estate. So there is specific credentials for valuing. As an example, we're talking about Mexico because it's a partner, Canada. The regulations for a certified appraiser for real estate in Canada or Mexico are not the same regulations that are required in the US. There are specific designations. The highest and most common is a Royal Institute of Chartered Surveyors, or FRICS, and that a number of our appraisers have those credentials and can technically value property anywhere in the world by law. For the IRS purposes, the IRS would want to see a credential that is relevant for that country. And I'm speaking about real estate. If you're talking about valuing a partnership interest, as Yulissa just mentioned, or an operating business, then the credential, as far as we're concerned and what we've seen, is a credential for a party who is a CVA, BVA, CFA that has the credentials in the US and is seen by the IRS as a credentialed party to value businesses and partnership interest in the United States. So you don't have to have an appraiser who is credentialed with financial valuation if you're valuing a partnership that happens to be in Mexico, that they are credentialed in Mexico. They could be credentialed in the US because this is for IRS purposes, and they would accept that. That's what we have seen ourselves in the work we do. But I will tell you that even for us, we're valuing a number of properties in Canada right now, as well as in Mexico, and obtaining appropriate market data and trying to be within the confines of what you're trying to achieve for the appraisal for your purposes. That's very important. You convey that to your appraiser. It's very important because the data points for real estate can be very challenging and they are not readily available. And candidly, in some cases, you actually have, we as appraisers, we just got done appraising some properties that came in the BVIs in the British Virgin Islands, and obtaining sale comps was almost next to impossible. So there were a lot of hurdles that had to be done to get that information. So the appraisal was reputable. And the time and effort to do it, I can tell you in the case of the BVIs, it probably took us 4 times the amount of effort and time to get the information. So just, again, whoever you're speaking with that you want to engage to do the work, make sure they're qualified and understand what they need to do in that market. Go ahead, Yulissa.
Yeah, I think just another important, and sometimes it's hard to find somebody, if you can have somebody local who can help, facilitate that
Yes.
information, it's a huge help. But sometimes it's hard to even find someone, who can provide that information based on what we need, right, from the US side. So I want to highlight the importance of qualified appraisals because I see even professional fiduciaries using brokers' letters of opinion for different things, and that's forget the tax side on the trust administration, litigation side. That's not that leaves room for breach of fiduciary duties, fair market value issues. So I would steer away from that. And then I just want to highlight again, statute of limitations, right? If we don't get a qualified appraisal and we're using a certain tax basis on, for sales, even a regular sale, right? Where I'm saying this is what the tax basis is and I sold it for $1 million more. IRS can come back. We don't have an adequate appraisal because I didn't get it on the first death. I have a problem potentially on that. So the other thing I want to, oh, I think, did I double the slide? I totally did. Again, nuance. I know it sounds like a lot of detail that we're giving, but in one court case where the numbers were transposed for the LLC, that was enough for the IRS to argue that it didn't satisfy the adequate disclosure requirements, and it became a court case, right? So again, the nuance, the detail is important. So just for you to know there. Okay. So I don't know if anybody's ever done a foreign probate or ancillary. Has anyone? Was it easy?
You can unmute if you like.
Yeah. Ooh, I lost it. Okay. Well, it's not always fun, right? And the rules don't always work well together and they don't make sense from our perspective, from their perspective. What we have available doesn't. I mean, we were litigating here a Spanish will, and the court in California wanted us to produce the original. Well, we can't because the notary keeps it under lock and key and they keep the original, right? So just having to go through a lot of those explanations make it a little bit more complicated. You're educating judges, beneficiaries, colleagues about all this. And we often still find multiple wills that are competing. And what I mean by that is I'm working right now with a client that came from a pretty large firm, and they did the US side of the planning, and then the other wills from Mexico revoke everything. Right. So when you don't work well together, we have more issues. So we see that a lot. And if I'm a fiduciary trying to figure out how I'm administering the estate, make sure you ask if there's property abroad, is there a will that disposes of that? And then the other issue that we often see is if you have your generic pour over will here in the States, well, I can have issues because the trust isn't respected in that other jurisdiction. So does that pass intestate? Do I have forced heirship? So just something to be aware of that comes up a lot. Advice there is make sure you ask to see if there's other powers of attorney or wills, and if there's been any transfers in the other country in which your decedent or principal may have assets. Okay. The other thing that I want to point out is international mail. These silly things, but important. Probate code notice to make sure, again, that kicks the statute of limitations. It has to be via international mail. And then sometimes for certain contexts, you also have to notify the consulate. Okay. Any questions? I have some case studies that we'll get into, but I think we went pretty quickly. Any questions so far? Okay, so I'd love to hear, or you can put it in the chat, some issues just based on the information that I've given you so far. I'm going to read you a fact pattern, and I can almost bet you, that you'll be able to identify some things that, that you see. So Julie is a professor at UC Berkeley. She's a dual French and US citizen. She retired in France, which is where she grew up and lived there the last 3 years of her life in Paris, where she met Jane and who she marries while visiting in California prior to her death. While in France, Julie opened a few bank accounts that she used to pay her bills and also bought a rental property in a corporation. All of her beneficiaries are in France. She has an existing estate plan which includes 2 wills, one French, one from California, and a revocable trust for her U.S. assets. Jane, a French citizen, survives Julie and is the primary beneficiary of Julie's estate. Any issues you see? If you're the principal under power of attorney during Julie's lifetime, what would you be doing? What about after death?
Anybody want to unmute and ask a question directly?
Well, I'll give you some pointers. Well, we have, first of all, same-sex marriage, is it recognized, right? So here we have France, so it is, but other countries, you still have to consider that. Second of all, if she moved during her lifetime and she opened bank accounts, we have a reporting issue during life, right? So if you're a power of attorney in the US, and we did say that she has an existing plan, so there would be somebody named under the power of attorney, that would be an obligation to continue to report, file taxes, etc., which wasn't happening. And that liability can carry over to her estate. I have two documents, one in France, one in the US. Do they work well together, right? These are all issues. If it's coming from trust, I didn't even touch on this, but it can, let me go back to this. If the primary beneficiary is Julie's spouse and it's coming from a trust, even if there's a marital deduction equivalent in another country, it may not apply because it's coming through a trust, right? So you also have to be careful with that to make sure that you can get the maximum of whatever the deductions and exemptions are. The 14 million that we have in the US is pretty high, and especially in comparison with other countries, including France, which has an inheritance tax. Okay. The other thing that I didn't mention is, do we have a foreign trust for US tax purposes? Once she moved abroad, she kept her revocable trust here. She was still trustee. Well, does my court have jurisdiction? Does it become a foreign trust? Did she file all the requisite 3520A forms? And the answer is probably not, right? And then kind of your job with the attorneys and accountants to figure out, well, what are we reporting? What are we cleaning up? And how do we move forward from here? But it's important for you to, again, just know that these issues are there, and it takes a minute and some digging and some, analyzing of how we're going to kind of get out of that hole. But that's, part of the nuances that you just have to work through. Okay. The other thing that I often see missed is inheritance trust. I'm sorry, inheritance tax. If I have assets in two jurisdictions and my basic revocable trust, my default language says this trust pays everything. But when she retired, she bought a $3 million condo in France that's subject to, 50, 60% tax. Who pays that tax? Does the beneficiary in France or does my trust? Because my trust said that this one, the trust pays. Did the trust anticipate that? So when you're dealing with dual countries, even states sometimes, because we have a state tax in other states, you have to make sure that the trust considers that. And if you're onboarding a client as trustee and you know that they have assets abroad or could move abroad or may move to another state, it's important for you to, have your attorneys look at these issues. Are taxes addressed? Again, because then you may be stuck petitioning the court for instruction as to who does what, right? To make sure that the beneficiaries, if they're different, because France goes through the French will and the revocable trust beneficiaries may be different, that the beneficiaries who are absorbing, in essence, that tax, aren't later upset at the trustee for paying it. So again, that's how it comes up more often than one thinks. And that's what you should be looking for in your documents. Okay. Some countries with forced heirship, that still applies. There's ways around it. That's what this EU regulation is. You can elect a place of domicile to control. So for people that may own property in France, they can actually elect that the laws of their home state apply. One interesting fact is that it says the country, not the state. And on the US, we don't have country rules about intestacy, right? We have state specific rules. So there's not a lot that I know of yet on this because it's still somewhat new. So I haven't seen a lot of litigation over this. But that has always been a concern, that if I say I'm a California resident, I'm electing California rules, then is that enough to serve under this regulation? And I think most people would say yes, and that's a position we've taken, but just something to be aware of. So John, US citizen, moves to Australia for work. He's lived there for 3 years and he becomes incapacitated. You're his agent under a power of attorney. He sets up in California before he left. You discover he had a few bank accounts that he opened while in Australia and a superannuation fund. What issues come to mind? Same thing. If you're the agent under a power of attorney, right, you're responsible now to file the tax return. Well, if he had a few bank accounts and he never reported them, do you go back and do that? Do you move forward? How do you become compliant? So there's a lot of options, but if you're the agent under the power of attorney, this is what you should be thinking and the questions you should be asking. What else do I have to do and how do we become compliant? Okay. So just again, quick takeaways, which I think I started with this at the beginning. I gave you a lot of rules. And again, put that little box, that cheat sheet on the wall. It's just important things to remember. When you have U.S. or non-resident beneficiaries, people abroad, non-resident grantors, trustees, the issues are different. The issues can be different, and they most likely are. And if you're in charge of administering their estate while they're alive or after death, it's something to be aware of. Qualified appraisals for sale purposes, for date of death valuation purposes, super important. It can mitigate some of the, not the audit risk, but let's say well, maybe, but it can mitigate any issues we may have over valuation with the IRS. And, the larger states that do get audited will, then we have less to argue about, right? So get good appraisals, work with people that are in this space. And that's probably the best advice that I can give. We don't, you don't need to know all the ins and outs, just know that there's different rules that apply. And make sure you have a good team. And that's pretty much it.
I'd like to add just something for everybody who's listening. And we're selling a property in, as I mentioned, in Cancun for a trust, and nuances of selling real estate outside of the US. Obviously, they're relegated to requirements, legal and gift tax purposes and gifting purposes from country to country. But for many of you, because Mexico seems to be, at least what we see, a very common place for people to own real estate, be it right across the border all the way down to in this case, Cancun. There are many legal issues in Mexico regarding the actual transfer and sale of real estate that not only can slow the process down, but almost impede it completely. And one of the things that we're finding, and we've sold many properties in Mexico, but is employment. Yulissa may be able to speak about that, but employment of anybody that has anything to do with the property, caretaker, landscaper, um, somebody who's done work on the house. There are very, very specific and onerous Mexican laws that require those payments and releases to be made to those parties so they do not file a claim or hinder the sale of the property. Additionally, that another thing we find candidly are family members or related friends of family members that are living in a property. They do not have a lease. They do not have any written documents that state they can live there, only that my mother's sister said Betsy could live in the house for a year free. And then all of a sudden you decide you want to sell the house and you have a tenant, and the issue of that tenancy again in Mexico is very, very difficult to manage through the sale process. And candidly, we automatically require our client to get an attorney in that province where the property is, and the transaction is done through Yulissa, you could probably speak to this, a notario. So there are a lot of nuances to selling and valuing property in Mexico. I'm speaking specifically about, but Canada as well. Um, and so yes, you do want to have a good understanding as to what it is that you're selling. What do you have ownership in? Is that ownership legitimate? I mean, I can tell you candidly, quite often we are tasked with trying to find out, is that property owned by so and so and so and so? And how do we get that information? And again, in certain, in Mexico is very challenging. And there are very few title companies that have title information that can provide that. So, a lot of, candidly, a lot of money is spent trying to get the information, obtain the appropriate way to sell the property, or even transfer it, right, Yulissa? I mean, I think, you've been experienced with that many a time. So, um,
Yes, you have to be very careful. I'm an attorney on this side, your fiduciaries as well. You have to be very careful in how things are run in certain places. It doesn't always, match with what we're supposed to do, our ethical duties are, and we want to do it right. And that just may not be how it works in practice, right? And I'm not just talking about Mexico, right? And it's I mean, we had a property in Thailand that we were selling, and we had to do some maneuvering through the attorney and through, trust accounts over there to move. It can be a bigger issue. And again, it's not always about the money, right? It's about what are we trying to sell and how are we going to get the money back into the States? That can be complicated
mm,
also.
yes.
And I think to your point, Todd, depending on the country, on the jurisdiction, Mexico has, if they're super strict with their labor laws. And
Yep.
those if you don't pay your household employees, they can attach a claim to the home, which can then disrupt the sale, right?
That's, yeah.
And so there's a lot of issues like that, for us, a mechanic's lien is probably the closest I can think of it, but something has to actually get filed. It has to be public record, et cetera, right? So there's a lot of different things to consider, and you absolutely always should work with local counsel, even if, for example, I feel confident in certain jurisdictions because I work a lot in them. I'm not a local attorney. I don't keep up with, the new rules there. And we should always have somebody local to advise us on the best way on how to accomplish the transactions that we need to do. So, yeah, I
Yeah.
think,
Does
yeah.
anybody have any questions that they'd like to just unmute and ask Yulissa? Um, Anybody have any thoughts, anything that they?
I had a question.
Yes, please.
Um,
Hi, Danielle.
hey Todd. Thanks, Yulissa, for explaining the information on foreign gifts and the filing of those forms to let the US know that you've received money from a foreign person. Is there any sort of generation skipping transfer tax issue that I should be aware of if, say, grandpa's in Mexico and wants to make a gift? Grandpa's in Mexico, Mexico citizen, doesn't touch the US, but wants to make a gift to a trust or maybe a grandchild individually in the US?
Sure. Is it are the assets in the US or in Mexico?
Mexico.
Okay. And then are you an attorney or a fiduciary?
I'm an attorney.
Okay, so from the reporting side, it's the 3520. From the planning side, depending on how much money that we're talking about, if they're foreign side assets, they don't even touch the GST. So if we're talking about a larger transaction, usually what we do is we'll create an irrevocable trust here in the
Yep.
US for your US beneficiaries to receive those gifts. So they are forever exempt from GST. Like it will never be a thing, right? So generally not in California, go out of state, South Dakota, Delaware, Nevada, Wyoming, to have that perpetuity built in. Is it worth it for $100,000? No, but depending on the size of the transaction, that's normally what we would do if it's during lifetime. If it's on death, then you may be setting up revocable foreign grantor trust to kick into those dynasty type trusts locally in the States to receive that. But there's huge planning opportunities there for those gifts. Yeah.
Perfect. That's what I was hoping you'd say. Thank you so much.
But then the trustee has to file the 3520 on the
Yes.
receiving end. Yeah.
Yes.
Mhm. Yeah.
Anybody have any questions? Any other questions for Yulissa?
Yulissa,
Anything? Yes, go ahead. Hi, Danielle.
hi, this is Danielle Campbell. I'm a fiduciary.
Hi,
Um,
Danielle.
Hi, I had a question on your 1042 form.
Hmm.
You kind of, and I think I understood this right. You said, so if it's a US person giving to a foreign beneficiary,
Mhm.
then we're basically withholding within the trust that that withholding amount that we're supposed to, and they can file for a ITIN and go after the withholding, correct?
Correct. So there's two things. So you only have to do withholding on the income that you're distributing. So arguably, if you pay it through the trust, there's no real income that you're distributing out. And then that withholding, the flat amount's usually 30%, but it can be modified based on the treaty, depending on the country. Let's assume it's 30%. If there's $1 million of income that you're, or even 100, let's say $100,000 of income that a non-resident beneficiary is entitled to, then you're responsible to withhold that $30,000. You would usually ask the beneficiary to get a TIN through a W-8 Benny form. Well, actually, no, that's the treaty claim. Sorry. The W-7, you get the TIN through that. And so you do the withholding, and then they can file a return to get that back later. So the W-8 Benny is if you want to, if the beneficiary wanted to avail themselves of a treaty, and then they would put what the treaty is and what it's not 30, it's something else, and then they would provide that to you or to the accountant to then minimize the withholding. So that's generally the rule. And yes, you can be liable if you don't do the withholding, because you'd be the withholding agent in that situation.
Okay, because many of my situations have been beneficiaries abroad, in Canada or the UK, where pretty basic treaties, but these people are elderly. They don't know what ITIN is. They don't want to listen.
Right.
They don't want to do it.
Right.
So I just basically, to relieve the trust and myself of liability, explain to them, you can go do this if you prefer, but I've withhold the correct amount, and then you can go after it and get your ITIN.
Yeah, and I think that's what I've done too. But if you withhold it and you're supposed to pay it to the IRS, what are you paying it towards? You need a TIN for that. You need to say, I'm paying this on behalf of Danielle. Here's her social security or her ITIN, right? So then they can go back and get it. You did your job. Whether they go back and get it, that's not your problem. That's up to them. But you did your part on the withholding side. And I've had the situation. That's why I said in practice, it's easier said than done, right? Because who's going to go get the form and fill it in, and if they're older they're just not going to do it, right? And so what do? Because you have an obligation to get the beneficiary their funds, but you also have an obligation to make sure there's compliance. So you're kind of stuck, and you can distribute the funds but always do the withholding. And if you give it to the IRS in that way, it's kind of in limbo, I think, because there's no TIN attached. The other way is just have the trust pay the tax. So then there's no income and you're just distributing principal, right? If the trust is paying the tax, then then there's no withholding requirement. Does that make sense?
Yes, thank you.
Mhm.
Well, everybody, I want to say a couple of things first. Our next fiduciary education forum presentation is at the end of October. I think it's the 31st. You'll see invitations coming up, and it's on a very interesting topic. It is on what many of you may not know about but may need, and that is, what is a provisional director? A provisional director's role, how do they solve problems? How do they solve tie-breaking issues? Provisional directorship is becoming quite common. We're seeing it, and we've got two experts to speak about what is a provisional director and how you might be able to use them in your course of business. So that'll be at the end of October, and and that'll again be on the Fiduciary Education Forum website. This presentation and the video itself will be on the Fiduciary Education Forum website in the next few days. And of course, there's a library of years of presentations and documents there for you to view. Quite valuable. It's just a great education library for you all. So look, I want to say thank you to Yulissa for taking her time to make this presentation, and to all of you for joining us again. And I want to, any questions? Yulissa, do you want to give your email address
Sure.
please?
I don't know if you shared or if you posted the
It
presentation.
will be. Yes.
It's at the end. It's just my first name, Yulissa at JKZ LLP. Feel free to shoot me an email. Happy to chat any questions that you may have.
And for me, it's Todd, Todd, at braunco.com, or for those of you who know me at Premier Estates, Wohl at premierestates.com. And I want to thank all of you for joining us and have a good rest of the week. And we look forward to seeing you next month. Thank you, Yulissa. Thank you,
Thanks,
everybody.
everyone. Thanks for joining. Thanks, Todd.
Thank you very much.